Welcome to the podcast Sophie au Pays des Possibles, the first podcast in French about the women and men that tackle corruption and tax evasion. I'm Sophie Lemaitre, the host of the podcast. Today is a special episode that was recorded in English. My guest is Pusetso Morapedi from Integrity Initiatives International. With Pusetso, we discussed the idea of creating an International Anti-Corruption Court, or IACC. With her organization, she coordinates a group of experts who are drafting a treaty. In this episode, you'll know more about the IACC, its origin, its missions, and the next steps to make the court a reality. Enjoy the episode! Hi, Pusetso Morapedi. Thank you very much for joining us in the podcast. We're very happy to have you today. And today we will be discussing an idea or project that is not well known, at least in the Francophone world, the creation of an International Anti-Corruption Court. But before we talk about the International Anti-Corruption Court, could you tell us a bit more about yourself? Tell us how you ended up working on corruption.
Well, thank you very much, firstly, for inviting me and for inviting III, that is the Integrity Initiatives International, the organization for which I work, to come and share. I am Pusetso. I come from Botswana, a country in the southern, actually I would say it is the heart of Southern Africa. It is well known for diamonds. The biggest or second biggest diamond was discovered recently with about 2,400 carats apparently. But I hail from the northwest part of the country, from a village called Maung, which is the gateway to the Okavango Delta, if you've ever heard of the Okavango. And if you've never, please do look it up and come visit. Our tourism is one of the best in the world. But how I came to work in the anti-corruption space really started when I was young. I was raised by my grandparents, and we were in a remote village called Goshe, also in Gangwa, which is where the primary school was and still is, about 200 people back then. I think now Gangwa is about 1,100, population-wise. So growing up in that small setting, you learn about community and serving community as a purpose in life. My grandparents did that. My grandfather was a counselor for a long time. My grandmother, a farmer, always, helping people out. And that instilled a culture of helping. When I was in high school, really started in junior school, I became a peer educator under the Young Women Christian Association. And as a peer educator, you learn a lot about social ills and how to discuss them with your peers. And I think that the approach really is to have peers open up about, finding solutions to the problems that they face and that they encounter in life. And that exposed me to the problem of HIV/AIDS. This is now in the late 90s, early 2000, that after high school, I would continue volunteering for the Young Women Christian Association. And that exposed me to poverty in rural areas, and just understanding exactly how government plays a role in fighting poverty or in exacerbating poverty. And that led me to doing some research on how I can serve. Remember, I grew up in a community serving environment with my grandparents. After university, I volunteered for the UNDP. So they had a national UN volunteer program that I joined. And I coordinated facilitated about 36 small villages in the Okavango sub-district. And I usually say in that district at the time, I could see poverty and HIV/AIDS walking in the streets. And we were tasked with finding local solutions to the prevention of HIV, but also the reinfection of HIV. And we formed support groups, worked with multi-stakeholders in the villages. And that really propelled me to the idea of serving at the national level. That when I finished my master's in politics and international relations, working in governance, peace and security department of the SADC Council of NGOs, I interacted with an anti-corruption expert group that I coordinated for a year. And my interest in fighting corruption using transparency and accountability as approaches to ensuring that citizens benefit from public goods and services then became a passion and a lifelong mission or assignment, I guess, for myself. So that's how I really got to then engage and interact with III at some point, being in the Africa subcommittee for the International Anti-Corruption Court. Because at the end of the day, I understood that national level legal systems sometimes fail. Sometimes they are unable to prosecute grand corruption or senior officials who are closely related or close to the centers of power at the national level. The calling called and I answered, and now I'm the Africa coordinator for III, that is the Integrity Initiatives International.
Thank you. And that's really interesting to hear, the different steps that led you to work on anti-corruption. It wasn't like you knew from day one, but it's really your background, everything you experienced that led you to this. So thank you so much for sharing your story. You mentioned III, so Integrity Initiatives International. Can you tell us a bit more about this organization? I don't think this is well known, so it would be great to hear more about what you guys are doing.
III, as we usually call it in short, the Integrity Initiatives International, was established in 2016 by one judge, Mark Wolf, and his peers, Justice Richard Goldstone of South Africa. He used to be a constitutional court judge in South Africa. And this really came about after Judge Mark Wolf wrote an op-ed for Washington Post, basically about the need for an international anti-corruption court, how that would actually help fight kleptocracy and grand corruption. So III actually just coordinates the network of governments, of civil society organizations, international jurists, anti-corruption experts, and individuals like myself who are interested in fighting corruption. III coordinates all these actors and all these people involved in the international campaign for an international anti-corruption court. It also, III, being established in 2016, also manages IACC, that is the International Anti-Corruption Court in short, model treaty drafting project. So what we do really is to help strengthen the enforcement of criminal laws to punish and to deter leaders who are corrupt at a grand scale.
So you mentioned the IACC, so the International Anti-Corruption Court. Can you tell us how this idea came up? What is its origin? What led it to the idea that we need a new court? Because we already have one, the International Criminal Court, and now there's this idea on the table of an ACC. So why should we have this court? I know it's a lot of questions and we'll probably split up, but at least tell us the origin of this idea.
With what is happening in the world, we know that corruption has been around at time immemorial. We also have the UN Convention Against Corruption. However, the mechanisms to enforce the crimes stipulated in the UN Convention Against Corruption, we do not really have. It's all left to the national level. But we see the consequences and the repercussions of corruption. We see the consequences and the repercussions of illicit financial flows. We see the consequences and the ramifications of assets that have been stolen from the public, from the people benefiting a few, that he wrote this op-ed, and an article for Brookings Institutions saying that the gap that we have, how to fill it would be using an instrument such as an international anti-corruption court. And he was cognizant of the fact that we actually have the International Criminal Court. Some would ask, but why is it necessary to have the IACC when we have the ICC? And I think it's an issue of what would happen if we were to add grand corruption under the jurisdiction of the ICC. Already we know that the ICC statute does not cover crimes of corruption. It wouldn't cover money laundering. It does not cover embezzlement. It does not cover bribery. So we do need an organ that can actually cover that. If we go back to the ICC as well, just amending it would require a 2/3 vote by its 123 member states, right? And also the ratification process will have to get into effect. Now, the likelihood of ratification or the likelihood of amending the ICC and then ratification, I think would pose a longer term in terms of what we need right now to fight grand corruption. So looking at some of these practicalities, Judge Mark Wolf came up with the idea of the IACC as one of the many responses to fighting grand corruption and prosecuting kleptocrats or leaders who basically steal from their citizens and from their countries.
You mentioned a couple of times grand corruption. How would you define it? What does it look like?
So grand corruption is a matter of scale and magnitude, one would say, because corruption in its simplistic definition, if we're to use Transparency International definition, it is the abuse of public power and trusted public power for private gain. Now, grand corruption would take that definition and then increase the magnitude of the abuse of power and by whom the abuse is undertaken for private gain. So it will also include, at certain levels, the nation's leadership or the nation's leaders, senior officials in government or in the public service. It may also extend to the private sectors, those who are particularly in the state-owned enterprises or parastatals, your CEOs and their senior management. So grand corruption would look at the magnitude of the corruption itself and by whom it has been commissioned. And if you go down to what kleptocracy is, because we keep saying kleptocrats, kleptocracy is a form of government in which leaders use their political positions. In most contexts, we have leaders or government leaders who deploy their own in certain positions, whether it is ambassadorial positions, whether it's permanent secretary positions, and those people then using those positions of power to gain or to increase their personal wealth by stealing money and valuable resource from the country or the countries that they rule. And this court, we're hoping, will actually be the instrument that could prevent that could deter and where possible punish those that would have been criminally charged with stealing from their own.
Thank you. And for those that are listening to us, could you give them an example of what a grand corruption case look like? Just so that it's more concrete, because we understand that it involves high-level public officials, but in reality, how would it look like?
If we take Namibia, one country in Southern Africa, and we take the fish rot scandal. This fish rot scandal included a minister who facilitated an Iceland country, largest fish industry company, Samjeri, to actually manipulate quotas and how they got rights to fishing, right? So what happened then was that kind of corruption then literally perverts the system and the integrity of quota system in the fishing industry, hence the fish rot, name or the fish rot scandal. If you look at the turnover of the company that actually was involved, I think it's around $700 million, and one of the largest fishing companies in the world. One of their directors got involved with some of the directors in Africa, mainly Namibians, but also fisheries minister. He was newly elected. They worked around to exchange quota fees to be paid to the presidential party, allegedly, and several top Namibian officials and businessmen. So for this company to ensure that they get the contracts, they managed to bribe, they managed to pay, and they managed to literally sway the ties to their own advantage at the expense of what could have been maybe even quality compromise. If there was any quality compromise, the state couldn't have done anything because these people, this company managed to get the quotas for themselves. So the amount of money involved and the actors, and in this case, a minister of fisheries involved, makes it a grand corruption because it also affects not just a few people, but the state and its systems and its mechanisms of integrity that are in place. So the grand corruption really would also be in a case of Mozambique, where we have a minister of finance facilitating movement of money using state guarantees, where $2 billion $2 billion that was apparently taken by the state went into private hands. And now the state is stuck with having to pay that $2 million. That civil society had to stand up and say, no, Mozambique is not for sale, and you are not going to pay that $2 billion because it did not even come to the citizens. The citizens do not benefit from it. So now if you take $2 billion just to maybe paint a picture for people who have got small budgets like Botswana. I'm from Botswana. So $2 billion would be, we multiply that by almost 15. So that would be around $30 billion. $30 billion is actually almost 50% of Botswana's annual budget. That is the country's annual budget. Now imagine people taking that, a half of an annual budget of a small country or small population, and then dividing it amongst themselves at the expense of the citizens of that particular country. That is the grandness or the magnitude of the corruption and the grandness of the effects of it and the victims of that kind of corruption.
Your two examples really show the magnitude of corruption and also the impact on people's life. I'm thinking of this $2 billion, what we could be doing with this amount, building schools, having hospitals. It's really a good example. I mean, I think for us, for people, for citizens to realize how impactful corruption is and how negatively it affects people. So let's go back to the IACC. So you told us about the origin of the idea of an anti-corruption court, but now it would be great to hear, how would it work? What would be its mission? What would it cover? How would it function?
The IACC will eventually be established by a treaty, and a treaty is basically a legal framework or document that would say this statute, will establish the court. The different actors in the campaign, because you see, the campaign for the IACC is actually comprised of different experts. We have the international jurists, we've got former justices, we have anti-corruption experts, we've got international law experts who form different working groups that worked on different provisions of the treaty. And now this draft treaty outlines the establishment of a permanent institution that will hold high-level officials accountable. So the issue of accountability was one of the core principles of the IACC. And how the court will actually work is that it will only prosecute or have jurisdiction over universally agreed crimes found in the UN Convention Against Corruption. Because then the issue of, but why can't the ICC, that is the International Criminal Court, have jurisdiction over corruption? It's because actually it doesn't have jurisdiction over the UN Convention Against Corruption, but we have a legal instrument that what it needs is only an enforcement and an implementation mechanism, and the IACC treaty seeks to actually fill in that gap. So the IACC will also facilitate the appropriate return of stolen assets for the benefit of victim populations. So imagine if this case in Mozambique happened, and the Namibia case, even the DRC cases in the DRC where former presidents were involved. If you take Mobutu Sese Seko and how much money he literally siphoned out of DRC. And if we had an international court such as this one, and the state actually went to the court and sought some recourse, investigations done, and there was a mechanism to facilitate the return of stolen assets, can we imagine just how much the victims of corruption could benefit from repurposed or even, money going back to the intended purposes? So one of the things that I really like, one of the elements of the IACC that I like, is the fact that the treaty has explored the appropriate ways of returning stolen assets. So now the court is designed to be a court of last resort. It is important here to also underline the principle of complementarity. We are not saying that the IACC should replace national courts. The principle of complementarity requires that the IACC works with national legal systems. And if the chairperson, Mark Wolf, and even other vice chairs will always say that the IACC is the court of last resort. It is the court that will help countries that are willing to fight corruption but are unable or do not have the capacity to do so. So it is designed to be the court of last resort because people and states would have tried at the national level, but could not, for whatever reason, manage to investigate properly and prosecute properly. And the IACC is going to offer that investigatory division and prosecutory powers and prosecute with impartiality to the governments that will take cases to the court. So just to underline, the court's jurisdiction will cover the core crimes stipulated in the UNCAC, that is the UN Convention Against Corruption. And there we have bribery, and those who bribe, right? Those who bribe and those who facilitate bribes will be under the jurisdiction of the court. Embezzlement, money laundering by public officials, but also bribe payers and money launderers. And here we always talk about co-conspirators, that is the people who are accountants who help with how to launder money, implicated in money laundering, lawyers, other financial professionals that scheme and help the corrupt to move money across shores, hiding it in certain tax haven and other offshore accounts. Those people, those actors who committing those and helping corrupt leaders and kleptocrats commit these core crimes under the UNCAC will also be under the jurisdiction of the court. Maybe secondary level, one would say the IACC really seeks to enhance accountability for those who enjoy impunity. It is high time we dealt with impunity. And if we take Africa, for example, we have so many people who have suffered dearly, but also suffer psychologically because they see the people who have stolen from the state walk scot-free. We see people who have stolen driving beautiful cars and living a luxurious lifestyle with their children and their children's children, while the victims of corruption suffer in poverty, cannot get access to healthcare, cannot get access to quality education, cannot get access to quality drinking water, to potable water. And this court will offer that accountability element, the governance architecture at the global level. The court will actually, in addition to the criminal division, so the core crimes, embezzlement, money laundering, bribery, and what I really like I've said this earlier, this element of asset recovery. It will also have, as the treaty proposes, an asset division that will handle asset recovery and the return of proceedings, looking at unexplained wealth. It is interesting how it is normal for leaders who earn 40,000 pula a month, that is about $4,000 a month, all of a sudden driving cars that are valued at $1 million or $100,000. And then you ask yourself, how and where are you getting the money and the wealth to buy this when we know exactly how much you are worth and how much you are earning? So unexplained wealth orders shall be executed by the court. A seizing of properties, the court will also help governments with those, using their investigatory division to help ensuring that there is actually substantial and material evidence to prosecute eventually the case. In short, that's what the court really seeks to do, or at least the treaty now as we have it. And that treaty will be presented to states or governments that are interested to negotiate different provisions and then eventually use that treaty, even if it's a handful of countries, to then establish the International Anti-Corruption Court and come up with their measures to deprive corrupt leaders from actually benefiting from illicit wealth or illicit obtained wealth, and from benefiting from kleptocracy and fighting impunity in the long term.
When I hear and when I listen to you, when you explained us what the court would be doing, I think it's a great idea, but I wonder how it would be really in practice, because I can see many obstacles, and I'm going to play devil's advocate. You mentioned unexplained wealth orders that would help to seize houses, etc. But then you need cooperation from countries that do not cooperate. I'm thinking of Dubai, for example, or Hong Kong. So you need information from jurisdictions that are not willing to share information regarding grand corruption cases. And at the same time, I can't imagine the country where Minister X is accused of grand corruption to help the IACC and provide information and help seize the house. So how would it work in practice? How would we overcome these challenges? Because if the country doesn't cooperate with the court, how could the IACC really take the houses and cars and everything and then return it to the benefit of the people?
That is a great question. And some of the processes in actually establishing the court eventually is having party states, so member states to the IACC treaty, negotiate and look into ways of enhancing cooperation and enhancing this complementarity, enhancing consensus way of allowing the court to have jurisdiction over them. The moment that a country signs up and ratifies the treaty, it is basically saying we will shed off some kind of sovereignty, and at least absolute sovereignty, for the court to attain jurisdiction over our states and our affairs only for the case and only for the crimes, for the core crimes stipulated in the treaty. I think just like the ICC, that is the International Anti-Corruption Court, cooperation is always needed. You can have a warrant order, but if the states refuse or they don't arrest the person, the arrest orders, they don't arrest the person, then it seems like the court is ineffective or the court is only targeting a few. But sometimes it's because countries do not cooperate in arresting, even though they are party to the ICC. I think with the IACC, with the International Anti-Corruption Court, hopefully people knowing how transnational corruption is or transnational corruption crimes are and how those crimes actually impact every single person in the country, that one particular officer can actually be taken out and go and face the crimes that they have committed. It will be a process of negotiation by those who actually sign and ratify the IACC treaty. It's probably not a perfect response, and it's a good thing that you are the devil's advocate, because we also need to look at how do we enhance cooperation. Mutual legal assistances exist between countries, even those countries that may not be party to the IACC treaty, but maybe one member is, and maybe the money has been hidden in, say, Dubai or even Botswana, for example. How would the court then deal with that jurisdiction? I think it's an issue of strategy. Amongst one of the member states to the IACC, do we have anyone that actually has any MLA with this one particular country that is not party to the IACC, and can maybe on ad hoc basis request some jurisdiction just for that particular case, looking at its grandness and its magnitude and how it affects the people on the ground. I think it's an issue to be explored, how it will be done, enhancing cooperation and enhancing complementarity. So yeah, I think it was one of the questions that we grapple with, that we come up with, but how would we really make people or countries or leaders surrender? But I think as the treaty now is being almost finalized, the interested parties will look into what they will be comfortable with as governments in terms of drafting a provision that will enforce or even enhance cooperation.
You mentioned earlier that the court is of last resort. So does that mean that if I'm a whistleblower or if I work for an NGO and I'm aware of corrupt practices and I know that it's not going to be possible to have an investigation open, or if there is an investigation that is open, then there won't be any investigation and the case will stay on the shelf for years? If it's court of last resort, does it mean that I, as a whistleblower or as an NGO, I cannot submit complaints or information to the court?
That is a great question. The draft actually provides for civil society organizations to get access, especially international organizations or certain organizations of particular standing, maybe to the ECOSOC, to have access to the court. But it will have to be through a member or a party, a state party to the court. But that will be up to the governments that will negotiate will look at the treaty and negotiate and leave that provision for the access to civil society organizations. So as civil society organization ourselves, and as people involved in the drafting project, we would love for whistleblowers to be protected. We would love for victims and witnesses to be completely protected and to have access to the court. But eventually it is up to the government that will establish the court to leave that provision in the treaty or to take it out. If they really want to fight grand corruption and they are serious about it, and knowing the role whistleblowers play in revealing where the stolen goods are and who stole them, they will leave that provision or at least enhance a provision that allows access to the court by whistleblowers and their protection.
So you mentioned that there is a draft text for treaties. What are the next steps for the court to become reality, and how long could it take before we can have this IACC?
So the next steps would be finalizing the draft, and we're hoping that the drafter, especially the main drafter who is pulling everything together, would give us a final draft by November of this year. And then we will take III will then engage the different governments that have shown interest so far, because we have been courting different governments and different CSOs to support the campaign for the court. And we have a few countries that have been supporting, and they have declared their support publicly, some just by sending an email or even signing a declaration. So we will share this draft and engage the different governments on the draft, and thereafter have a final draft next year, March, so 2025 March, that can then be publicly shared. So we're expecting to share the final draft that would have had input from governments, some governments that are interested, by March 2025. And then if a few countries actually group themselves together and want to establish this, even if it's 30 countries or less, but hopefully 30, because we're looking, if we were to look at numbers like 30 out of 187 state parties to the UN Convention, that's not a bad or terrible number really. But the court could start with a relatively small number and then grow from there. And if these countries also have some cooperation agreements with other countries that are not party to the IACC yet, we will see how then the legal framework could be applied to also cover those countries on ad hoc basis. So between now and March, we're hoping to have the final draft publicly shared. And hopefully thereafter, literally following up with countries that have not shown interest to show interest, to engage, and then see who can actually take up the baton and the responsibility of establishing it.
Great. And so how many years could it take? Are we talking like a couple of months, or are we more like a decade?
If we are to look at when the idea popped up with our chairperson, our chairman, Judge Mark Wolf, that was 2014 when he wrote that op-ed. And then the organization to coordinate all of that was in 2016. That has been 8 years so far, almost 10 years at the beginning of the conceptualization of the ideation stage. That's 10 years. And then it rapidly, in the past 4 years, I believe, just gained momentum. I think the way corruption is producing victims, the rate at which it is, and the rate at which it threatens peace and security, and it threatens to cause instability, that momentum needs to be sustained. And with that sustenance of that momentum, we could actually see rapid moves in terms of needle and wheels moving, that it could be a case of 3 years, but it could also be slowed by other geopolitical issues and funding challenges, that it could take another 8 years. So I would say 3 to 8 years for it to be established, but I'm hoping for 3 years.
Thank you so much, Pusetso, for being with us today and telling us more about the IACC. That was really an insightful conversation. So we'll keep an eye and follow up what you guys are doing with this initiative. Thank you so much.
Thank you for having us and giving us an opportunity to share more about the campaign. And we're looking forward to engaging further, hopefully, next year when the draft treaty becomes public. So thank you so much.
Thank you for listening. Share this episode with your network. like friends, family, and colleagues to help spread the word. If you enjoyed it, you can listen to my other 2 episodes available in English, episode 19 about the Corruption Hunter Network, a network of prosecutors and judges from around the world, and the fantastic job they are doing to combat corruption. You can also listen to my conversation with Niels Kurbis on corruption and artificial intelligence. If you understand or speak French, check out the 45+ episodes available. You will hear amazing stories from NGOs, activists, whistleblowers, and researchers.